Welcome to the Deep Dive. This is where we take your information articles, research, maybe your own notes, and really plunge in deep to pull out the most important bits of insight.
Think of it as, well, a shortcut to being properly informed.
Exactly. With some surprising facts and, we hope, enough chat to keep you hooked. Every deep dive is unique, tailored just for you, the listener who shared the material. We're basically your guides through it all.
Helping you figure out what really matters in the sources you've given us. And today, we're tackling a really fundamental topic in intellectual property law, remedies.
Yes, and this whole deep dive is focused completely on the material you provided from Chapter 4, which is all about remedies.
And looking at remedies early on when you're studying IP is actually a really smart move.
Right, why is that?
Well, it gives you this fantastic overview, like a bird's eye view of the whole field. It shows you the practical side, the arguer, the teeth behind IP rights.
Ah, okay, so not just the theory, but what actually happens.
Precisely. It really highlights how important litigation is, not just for enforcing rights, obviously, but also for how the law itself develops through court decisions.
And it brings up that core tension in IP, doesn't it?
It absolutely does. That constant balancing act you see everywhere in IP law, protecting the owner's rights on one hand
Yeah.
and keeping things open for free competition on the other. Remedies really put that balance front and center.
Makes sense. Without understanding the what happens if, the rights themselves can feel a bit, well, abstract.
Exactly. Remedies are where the rubber meets the road. And for this specific deep dive, based on your material, we're going to focus on two main types of legal tools.
Okay, what are they?
First, the remedies you can go for before a full trial even happens, and second, the ones that are available after you've actually won your case at trial.
Pre-trial and post-trial. Got it. Now, before we really get into the weeds, we do need to say a couple of important things.
Yes, absolutely. We want to give credit where it's due. We're able to explore all this detail because the University of London has made these documents available for educational purposes.
So big thank you to the University of London for that. And just to be absolutely clear, this deep dive, like everything we do, is purely for educational purposes.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
And for any of you listening who might be using this to study, maybe getting ready for exams.
Good luck. We really hope this helps clarify things and makes you feel a bit more prepared.
Definitely. Good luck with those exams. All right, so let's set our mission. We're exploring the legal tools an IP owner has when someone infringes their rights.
But crucially, we're also looking at the limits, the constraints the legal system puts on those tools
Yeah.
because they are powerful.
Right. It's not just about having the power, but understanding how it's controlled.
Exactly. It's understanding the consequences, what the IP owner can ask a court to do, but also how the system stops those remedies being used unfairly to just, shut down competition.
Okay, so let's start with the basics. Section 4.1 in your material talks about general matters. Where do these IP cases actually get heard in the UK?
Right. So the big IP infringement cases, they usually end up in the High Court, specifically in the Patents Court.
Defense court.
Yeah, it's a specialist court, part of the Chancery Division of the High Court. But there's another really important place, too, the Intellectual Property Enterprise Court. People usually just call it IPEC.
IPEC, right, I've heard of that. It's meant to be more accessible.
That's the idea. It was set up to be, well, a bit faster and less eye-wateringly expensive than the main High Court. It can handle pretty much all types of IP rights, patents, trademarks, copyright, designs, the lot.
So it covers everything.
Pretty much.
Yeah.
The main limitation is that there's a cap on the damages you can get. Currently, it's £500,000, and also a cap on recoverable costs. So it's really geared towards smaller or medium-sized disputes.
Okay, so patents court for the potentially huge cases, IPEC for a broader range, maybe quicker, but with that damages limit, that makes sense. Now, where do the actual rules about remedies come from? Is it all in acts of parliament?
That's a really good question. It kind of depends on the specific IP right you're talking about.
Okay.
For most of the rights that are based on statutes, the ones created by acts of parliament like copyright, patents, trademarks, registered designs, the main remedies are set out in those acts.
So things like the Copyright Designs and Patents Act or the Patents Act?
Exactly. The CDPA 1988, the PA 1977, the Trademarks Act 1994, the Registered Designs Act 1949. You look in the relevant act and it will list the remedies available.
Right. But your material mentions something interesting here.
Ah, yes. What's fascinating, and the material points this out, is that a lot of what's in the statutes actually just reflects what judges had already decided in earlier cases.
So the acts didn't invent everything. They sort of copied the homework from the judges.
Huh. In a way, yes. Especially for remedies that came from the old courts of equity. The statutes often just codified principles that case law had already developed over time. There's a case mentioned, Coflexip SAV Stolt Comax Seaway from 2001.
Cool flex it.
Yes, Coflexip. The Court of Appeal basically said the statutory remedies for patent infringement were largely just stating what the existing case law already was.
That's really interesting. So judges figure it out, Parliament writes it down later.
Often, yes, particularly for equitable remedies like injunctions. And because this happened gradually for different rights at different times, you sometimes find these little slightly odd differences between the remedies in the various acts. It's just a result of how the law grew piece by piece.
Okay. And what about the rights that don't have specific statutes setting out remedies, like passing off or breach of confidence?
Good point. For those like passing off and breach of confidence, the remedies are purely judge-made. They've evolved entirely through court decisions over, well, centuries, really. It shows the influence of the old Court of Chancery, which dealt with fairness and equity.
Right. So for those, it's all about case law, not statutes.
Exactly. Injunctions, accounts of profits, fundamental there, developed by judges.
So we've got two main sources for the remedies themselves. The statutes for many rights, often reflecting older cases, and then purely judge-made remedies for others, like passing off. That distinction seems pretty important.
It really is. It helps you understand the nature of the remedy. But while the remedy itself might come from statute or case law, the process for actually asking for it in court, that's governed by something more modern.
Ah, the rules of the game.
Pretty much.
Yeah.
The Civil Procedure Rules, the CPR, introduced back in 1999.
The CPR, how do they affect remedies?
Well, they changed how all civil litigation works in the UK. The main goal, right at the start of the CPR, is dealing with cases justly, and that includes being speedy, fair, proportionate, and saving costs. So, while the old law tells you what you can ask for, the CPR tells you how to ask for it, the forms, the timings, how the case is managed.
Okay, the procedural handbook. Now, the sources also mention EU law, specifically the Enforcement Directive from 2004. That still matters, even after Brexit.
It does, yeah. This is really crucial. The UK put that directive, the Directive 2004-48-EC, into UK law using the Intellectual Property Enforcement,
Wow.
etc., Regulations 2006. And those regulations, like a lot of EU law that was enforced when the UK left, well, it's now called retained EU law.
Or retained EU law. Okay, so it's still part of UK law.
Essentially, yes.
Yeah.
It means UK courts still have to interpret UK IP statutes, the CDPA, the Patents Act, etc., in a way that's compatible with that enforcement directive and the 2006 regulations where they apply.
Even if UK law seemed fine before.
In many areas, UK law was already compliant, so maybe the direct impact isn't huge day to day.
Right.
But the material points out that sometimes provisions in the directive might nudge the courts to take a slightly different approach than they might have historically.
Like how? Can you give an example?
Sure. Article 13 of the directive talks about calculating damages. It says courts should consider things like moral prejudice caused to the right holder. Now, UK courts have always compensated for financial loss, obviously, but explicitly thinking about moral prejudice, well, that might subtly change how damages are assessed, maybe especially for rights like copyright, which have a personal element.
Interesting. So it adds another layer of interpretation.
Exactly. And the directive also has general principles in Article 3 saying remedies must be effective, proportionate, dissuasive. Courts have to keep those principles in mind, too.
So retained EU law, especially the Enforcement Directive, is still influencing how UK remedies are applied. It just shows how IP law isn't in a bubble, is it? It's shaped by history, procedure, international stuff. For you listening, have you noticed this mix of statute, case law, and these retained rules in other areas of law you're studying? It's a common pattern.
It's fundamental, yeah.
Hmm.
Knowing where a rule comes from helps you understand how it works.
Right. Okay, that sets the general scene. Where cases happen, where the rules come from. Now, let's get practical. What can an IP owner do right at the start of a dispute, before they've even proved their case in a full trial?
Okay, let's unpack these pre-trial remedies, sometimes called interim remedies.
And why are these so important? Why not just wait for the final court decision?
Waiting can be disastrous. While you're waiting months, maybe years, for a trial, the infringer could be causing huge damage. It could flood the market, ruin your market share.
Damage that you can't easily undo later.
Exactly. Irreversible harm. Or they might destroy evidence proof of how much they've sold, for instance. Or they could shift their money offshore. So even if you win damages later, there's nothing left to collect.
Right, so interim orders are designed to stop that kind of thing happening while the case is ongoing.
Precisely. They're preventative. Stop the damage, protect the evidence, secure the assets.
Okay. What's the most common one?
The most fundamental is the interim injunction.
An interim injunction.
Right.
Right.
Yes. It's a court order telling someone either to do something or, much more often in IP cases, to stop doing something like selling the infringing product until the final trial happens.
Sure.
The main goal, as we said, is to preserve the status quo, keep things stable, and prevent that irremediable harm.
Irremediable harm, meaning harm that money alone can't fix later.
That's the key idea. If damages at the end of the trial would be perfectly adequate compensation, the court's much less likely to grant an interim injunction.
Where does the court get the power to do this?
It comes from the Senior Courts Act 1981, Section 37, gives the court a general power to grant injunctions where it's just inconvenient, and the procedural details are in the CPR Part 25. Speed is vital, by the way. You need to apply quickly once you know about the infringement.
And the person asking for the injunction, the claimant, they have to offer something in return, don't they, in case they're wrong?
That's absolutely right, a crucial requirement. The claimant has to offer what's called a cross-undertaking in damages. Say that again? A cross-undertaking in damages.
Cross-undertaking in damages.
It's a formal promise to the court. You're saying, if I get this injunction now, but I eventually lose the case at trial, I promise to pay the defendant for any losses they suffered because they were stopped by this injunction.
Ah, so it protects the defendant if the claimant turns out to be wrong.
Exactly. It's a safeguard. The
Fair
court
enough.
might even ask the claimant to put up some security, like money paid into court, to back up that promise.
Makes sense. It's a powerful order, so you need to stand behind it. Now, how does the court decide whether to grant one?
Right. The principles here are really important, and they come from key cases. The absolute starting point, certainly in England and Wales, is the House of Lords decision in American Cyanamid v. Ethicon from 1975. Lord Diplock's speech is the key part.
American Cyanamid v. Ethicon, a real landmark. Repeat that. American Cyanamid v. Ethicon.
It really is. Lord Diplock basically set out a step-by-step approach. He stressed it's discretionary. The court doesn't have to grant one. And he moved away from needing the claimant to show a really strong prima facie case up front.
Prima facie, like looking very likely to win.
Yeah. Instead, the first question became, is there a serious question to be tried? Repeat that. The serious question to be tried. Basically, is the claim not just nonsense? Does it have some real substance?
Okay, serious question to be tried. That sounds like maybe a lower hurdle to clear initially.
It was generally seen that way.
Yeah.
But, and here's where it gets really interesting, there's a bit of, well, maybe tension with later cases. In 1996, there was a case called Series 5 Software v. Clark.
Series 5 Software v. Clark.
Yes. And in that case, Mr. Justice Laddie, a very influential IP judge, he argued that actually, when applying the American Cyanamid test, the strength of each party's case is often the most important factor in deciding how to exercise that discretion.
Hang on. So American Cyanamid says don't focus too much on strength, just ask if there's a serious question. But Series 5 says strength is the most important thing. How do those fit together?
It's a fair question, and lawyers still debate it. You could see it as maybe an evolution. American Cyanamid gives the basic structure. First, serious question. Second, adequacy of damages. Third, balance of convenience. But later courts, maybe using Justice Laddie's reasoning, often look at the strength of the case within that structure, particularly when thinking about the balance of convenience or whether damages would be adequate.
So if the claimant's case looks really strong, the court might lean more towards granting the injunction.
Exactly. Or if it looks weak, they'll be very hesitant. And it connects back to the adequacy of damages. If damages, maybe like a reasonable license fee in a copyright case, seem like they'd fully compensate the claimant later, the court, following Series 5 perhaps, might be less inclined to grant the interim injunction now.
So if money can fix it later, less likely to stop things now.
Pretty much. But then you have to contrast that with cases where money can't easily fix it. Think about that celebrity wedding photos case, Douglas v. Hello, Ltd. from 2005.
Douglas v. Hello, Ltd. No 2, the privacy one.
Right. The court basically said the harm from publishing those private photos everywhere, well, you can't really put a price on that invasion of privacy. Where the harm is not easily compensated by money, the court said interim relief should generally be granted. It really highlights how the type of harm matters hugely. Repeat that. Harm not easily compensated makes an injunction more likely. Douglas v. DO1.
Got it. Douglas v. Hello, Ltd. No 2. It's about the consequences of letting the infringement continue.
Exactly. Which leads us to the next big part of the American Cyanamid test, assuming there is a serious caution and damages aren't adequate. The balance of convenience.
The balance of convenience, weighing things up.
That's right. The court weighs the potential harm the claimant would suffer if the injunction is refused against the potential harm the defendant would suffer if the injunction is granted.
Sounds like a real balancing act. What sort of things do they weigh?
All sorts of practical things, like the size of the companies involved. Are they two giants slugging it out, like in Polaroid v. Eastman Kodak?
Polaroid v. Eastman Kodak, big U.S. case, right?
Yes. A famous patent fight? Or is it a big company versus a small startup? Or the other way around? Cases like Coroplast v. Harrison or Katnick v. Stressline involve smaller players. The court has to think if the injunction would be disproportionately damaging to one side because of their size or resources.
Coolplast v. Harrison, Katnick v. Stressline. Size matters. What else?
Public interest grounds. Remember the Russell-Uclaf v. G.D. Searle case?
Russell-Uclaf v. G.D. Searle, the life-saving drug one.
Exactly. Stopping a vital drug supply. That's a massive public interest factor. Also, did the claimant delay in applying? Are the parties direct competitors? How similar are the products? Is there a risk of putting the defendant completely out of business? What about investment? Jobs? Katnick v. Stressline was relevant there too, about investment risk. It's a real mix of commercial factors.
A very practical assessment. And then there's the Human Rights Act.
Yes, particularly in cases involving things like copyright or breach of confidence, where freedom of expression might be relevant. Section 12(3) of the Human Rights Act, 1998.
Section 12(3), what does that do?
It says the court shouldn't grant an interim injunction restraining publication before trial unless it's satisfied the claimant is likely to establish at trial that publication shouldn't be allowed.
Likely to establish. That sounds stronger than just a serious question to be tried.
It is. The House of Lords confirmed that in Cream Holdings Ltd v. Banerjee in 2004. Repeat that. Cream Holdings Ltd v. Banerjee. They said likely means more probable than not. So over a 50% chance of winning at trial.
Cream Holdings v. Banerjee. So if free speech is involved, the claimant has a higher hurdle to jump for an interim injunction.
That's right. It shows how human rights law can limit these powerful IP remedies. It really brings up that question for you listening. How do courts balance IP rights against other fundamental rights, like free speech or privacy? It's a constant tension.
Definitely adds another layer. Okay, so that's interim injunctions. Preserve the status quo, prevent irremediable harm, need a cross-undertaking, balance of convenience, likelihood of success, higher if HRA S12 applies, and damages not adequate. What's next in the pretrial toolkit?
Next up, we have search orders.
Search orders. They sound pretty intrusive.
They are extremely intrusive. A search order forces the defendant to let the claimant's team, usually solicitors, and an independent supervising solicitor enter their premises.
Enter their premises. To do what?
To search for specific documents or items listed in the order and preserve them as evidence. And the crucial thing is, these orders are obtained without notice. Repeat, without notice.
Without notice. So the defendant gets zero warning. They just show up.
Exactly. They arrive with the order and execute it immediately. The whole point is the fear that if the defendant was warned, they destroy the evidence.
Right. That makes sense if you think someone will shred documents or wipe hard drives. Where did this power come from?
The legal basis is now in the Civil Procedure Act 1997 and CPR Part 25. But it originated from a famous Court of Appeal decision by Lord Denning back in 1976. Anton Pillar, KGV Manufacturing Processes, Ltd.
Anton Pillar. That's the name you often hear, isn't it? An Anton Pillar order. Repeat. Anton Pillar KGV Manufacturing Processes, Ltd.
That's the one. And because it's so drastic, the Anton Pillar case laid down very strict criteria, much stricter than for an interim injunction.
Okay, what are they?
First, the claimant needs an extremely strong prima facie case. Repeat. Extremely strong prima facie case. Way beyond just a serious question. Second, the potential damage to the claimant must be very serious if the order isn't granted. Third, and this is key, there must be compelling evidence that the defendant has the incriminating stuff. A&D, there's a real risk they'll destroy it if warned. Repeat, compelling evidence of destruction risk. And finally, the order mustn't cause excessive harm to the defendant compared to what the claimant needs.
Extremely strong case, serious damage risk, real chance of destruction, and not excessive harm. That sounds like a tough test.
It absolutely is. Their main use in IP is grabbing evidence, finding counterfeit stock, sales records, customer lists, computer files, that sort of thing. The Columbia Pictures v. Robinson case is an example. Repeat. Columbia Pictures v. Robinson. Protecting IP by preserving evidence.
But bursting into someone's office or home like that, it must raise privacy issues.
Definitely. The courts are very aware of Article 8 of the European Convention on Human Rights, the right to respect for private life and home. The Chappell v. UK case involved a complaint about an Anton Pillar order on Article 8 grounds. So human rights are a big consideration.
Which means there have to be safeguards, especially because it's without notice.
Huge safeguards. Because the defendant isn't there when the order is applied for, the claimant has an extremely heavy duty of full and frank disclosure. They must tell the court everything relevant, even the inconvenient facts that might argue against granting the order.
Everything, even the bad stuff for their own case.
Yes, if they fail to do that, the order can be thrown out later, and the evidence they seized might be inadmissible. The Naf v. Dickens case is a warning about that. Repeat, claimant's duty of full and frank disclosure and the Naf case.
That duty seems absolutely critical.
It's the main check. Plus, just like interim injunctions, the claimant must give a cross-undertaking in damages.
Right, the promise to pay if they were wrong.
Yes. And the order itself has strict rules. An independent solicitor supervises the search. The defendant must be allowed to get legal advice. The search must be limited to what's in the order. It shouldn't destroy their business. Guidelines from the Universal Thermosensors v. Hibben case are now mostly in the CPR.
Your source mentions these being called the law's nuclear weapons. I can definitely see why now.
Yes, that phrase captures the potential impact. They're not granted lightly, only when absolutely necessary to stop vital evidence being destroyed.
Okay, so search orders secure evidence. What's the other nuclear weapon?
That would be freezing orders.
Freezing orders. Repeat. Freezing orders. Also without notice.
Usually, yes. Obtained without notice, but their purpose is different. Freezing orders aim to stop the defendant moving or getting rid of their assets.
Ah, money and property.
Exactly, to stop them making themselves judgment-proof, so there's something there for the claimant to actually recover if they win money damages at trial.
So, search orders, evidence protection. Freezing orders, asset protection. Both powerful, secret, preventative.
You've got it. The legal basis is similar. Senior Courts Act, S.37, CPR Part 25. They originated in another famous Court of Appeal case, Morava Compania Naviera, SAV International Bulk Carriers, SA, from 1980.
Morava. Repeat. Morava Compania Naviera SAV International Bulk Carriers SA, hence Morava injunctions.
That's right. They used to be called Morava injunctions. And the Morava case set out the key requirements.
Okay, what are they?
First, the underlying claim must be one the English courts can hear. Second, the claimant needs a good arguable case. Repeat, good arguable case. Maybe slightly less demanding than for a search order, but still needs to be solid. Third, the defendant must have assets could be in the UK, or the court can even grant a worldwide freezing order in some cases. And fourth, there must be a real risk the defendant will move or dissipate those assets to frustrate a judgment. Repeat, real risk of removal or disposal of assets. You need evidence for that risk.
Good case. Assets exist. Real risk, they'll vanish. Makes sense. Are there safeguards here too?
Absolutely. The order has to leave the defendant enough money for normal living expenses and usually for ordinary business costs. It also affects third parties like banks, so there are rules for notifying them. And yes, the claimant needs to give that cross-undertaking in damages.
Okay, so search orders for evidence, freezing orders for assets. Sometimes you might need both if you think the defendant will destroy files and hide money.
Precisely. They can work together. Now, there's another useful pretrial order, often used to find out who the infringer actually is. It's called a Norwich Pharmacal Order.
Norwich Pharmacal Orders. Repeat, Norwich Pharmacal Orders. What do they do?
They compel a third party, someone who isn't the main wrongdoer, but has somehow got mixed up in it, often innocently, to disclose information. Usually that information is the identity of the actual infringer.
So you use an innocent third party to unmask the real culprit.
That's the idea. It comes from the House of Lords case, Norwich Pharmacal v. Commissioners of Customs and Excise, back in 1974.
Norwich Pharmacal v. Commissioners of Customs and Excise. Repeat, Norwich Pharmacal.
Yeah. Norwich Pharmacal suspected patent infringement but didn't know who was importing this stuff. Customs and Excise had the importers' names. The court ordered Customs to disclose them, even though Customs themselves weren't infringing.
And this is still used, especially online, maybe.
Very much so.
Yeah.
Vital for IP owners tracing infringers online, often getting orders against ISPs or platforms to reveal user details. It's not just IP, though. Remember the Ashworth Security Hospital v. MGN case?
Ashworth Security Hospital v. MGN.
That involved ordering a newspaper to reveal the source who leaked confidential patient records. So it applies where a third party gets mixed up in wrongdoing. But there's a condition.
What's that?
The order is only granted if there's a pressing social need. Repeat, pressing social need. It's a check to make sure it's necessary, especially if it touches on things like privacy or, like in Ashworth, press freedom. The Human Rights Act, Article 10 on freedom of expression, was relevant there.
And can the claimant just use the information however they want?
Now, usually the court restricts its use. Typically, it can only be used for the purpose of bringing or pursuing the IP litigation against the person identified.
And this is different from the normal discovery or disclosure process in a lawsuit?
Totally different. Standard disclosure is between the parties already in the case. A Norwich Pharmacal order targets a third party to get information, often before you can even properly sue the main infringer because you don't know who they are.
Got it. Find the infringer via an innocent intermediary. Any other big pretrial remedies?
Yes, one more that's become increasingly important, especially online. Blocking injunctions.
Blocking injunctions. Repeat. Blocking injunctions. Sounds like website blocking.
That's exactly what it often involves. These are orders against intermediaries, think ISPs, search engines, maybe social media platforms.
The platforms themselves aren't infringing.
Right. The intermediary isn't the infringer, but their service is being used by someone else, a third party, to infringe IP. Repeat. Intermediaries.
So you force the ISP or platform to block access to the infringing stuff hosted by someone else.
Precisely. The legal power comes partly from retained EU law. Article 11 of the Enforcement Directive covers intermediaries for any IP right. Article 8 of the Information Society Directive specifically covers copyright, that's Section 97A, in the UK CDPA. But crucially, the UK Supreme Court confirmed in Cartier International AGV BT plc in 2018.
Cartier International AGV BT plc. Repeat. Cartier.
The UK courts also have an inherent power to grant these orders anyway, separate from the EU directives, so the power remains strong.
And courts have used this against ISPs.
Yes, there have been numerous cases forcing ISPs to block access to sites facilitating copyright infringement cases, like 20th Century Fox v. BT or Dramatico Entertainment v. BSB.
20th Century Fox v. BT, Dramatico Entertainment v. BSB. Okay. Is it automatic if there's infringement?
No, definitely not. There's a very important balancing act.
Yeah.
The order must not be disproportionate and must strike a fair balance between competing rights. Repeat. Not be disproportionate and strike a fair balance. Balancing the IP owner's rights against the intermediary's freedom to run its business, and also Internet users' rights to receive information. Courts look carefully at whether the block will be effective, how much it costs the ISP, the risk of blocking legitimate stuff by mistake. Cases like EMI Records v. BSB, FAPL v. BSB, and 20th Century Fox v. Sky UK wrestled with this balance.
So it needs to be carefully targeted, not just a blanket block.
Absolutely. The EU Court of Justice supported this proportionate approach, too, in the UPC Telecabel Wien case. And the approach has evolved.
How so?
Well, infringers just move sites, right? So courts started granting dynamic blocking orders. These aren't just for one specific website address. They can require ISPs to block new addresses or servers that pop up hosting the same infringing content. The FAPL v. BT case from 2017 is an example.
FAPL v. BT. Dynamic blocking. That sounds more practical against slippery infringers. What about the cost? Who pays for the ISP to implement the block?
Ah, that was the big question in the Cartier v. BT Supreme Court case. They decided the ISPs, as intermediaries, do not have to bear the costs. The IP owner who wants the block generally has to pay for it.
Right, the cost falls on the rights holder, not the neutral platform. That's a key point.
A very key practical point.
Wow. Okay, that's a powerful set of pretrial tools. Intro injunctions, search orders, freezing orders, Norwich Pharmacal, blocking injunctions, all designed to stop damage, preserve evidence or assets, or find the culprits before the main event.
They are indeed powerful, but as we've seen, all subject to strict tests and safeguards.
So that covers the pretrial phase. Now, what happens if the IP owner goes through the whole trial process and wins? What remedies can they get after the judgment?
Right, post-trial remedies. What happens once infringement has actually been proven?
And the most obvious one is surely stopping them doing it again permanently.
Absolutely. The main remedy is usually a final injunction.
Final injunctions. Repeat. Final injunction.
Right. The purpose is simple. Permanently stop the defendant from infringing that specific IP right in the future. It's the court saying, you were wrong, now stop it for good.
And the power for this comes from the statutes again.
Yes. The main IP Acts provide for final injunctions. TMA Section 14, CDPA Section 96, PA Section 61, RDA Section 24, and so on. The wording often follows the statute, as Aldous LJ noted in that co-Flexip case we mentioned earlier.
Are they automatic if you win?
Technically still discretionary, but you'd almost always get one if infringement is proven and likely to continue. They might refuse if there's zero risk of repetition. And importantly, if the IP right itself is later found to be invalid, the injunction can be discharged, canceled. That happened in a later Coflexip case, Coflexip v. Stolt Offshore in 2004. Repeat, final injunctions discretionary can be discharged if IP invalid, Coflexip cases.
How long do they last?
Usually just for the remaining life of the IP right. So a patent injunction ends when the patent expires. But here's where it gets really interesting. There's something called springboard relief.
Springboard relief. Repeat. Springboard relief, like getting an unfair head start.
Exactly. It's designed for situations where the infringer, by infringing, got an unfair competitive advantage, a springboard that would let them jump straight back into the market the moment the IP right expires. The key case is Dyson Appliances v. Hoover, No. 2, from 2001.
Dyson Appliances Ltd v. Hoover Ltd No. 2. Dyson versus Hoover, the vacuum cleaner battle.
That's the one. If the court thinks the infringement gave Hoover an unfair springboard, maybe they perfected their manufacturing using Dyson's tech, the injunction could actually last longer than the patent itself.
Longer? How long?
For however long it would have taken Hoover to develop the product legitimately without infringing. It neutralizes the head start they got illegally.
That's clever. It stops them benefiting from the past infringement even after the right ends.
Precisely. Now, another important aspect of final injunctions is that public interest point we touched on with interim ones. Can it stop a final injunction too?
Right, especially with medical stuff.
Yes. The courts have to weigh this carefully. Remember, Edwards Lifesciences v. Boston Scientific from 2017.
Edwards Life Sciences, LLC v. Boston Scientific Seamed Inc., the heart valve case.
Right. The valve infringed a patent. For some patients, it was the only suitable option. The court delayed the injunction to protect those patients. Public health trumped the immediate patent right.
That makes sense in such a serious situation.
But contrast that with eValve Inc. v. Edwards Life Sciences Ltd. in 2020.
eValve Inc. v. Edwards Life Sciences Ltd., another medical device case.
Yes. Infringement found, but the defendant argued against an injunction, saying some doctors just prefer their infringing product. Justice Burrs granted the injunction.
Why the different outcome?
Justice Burrs clarified things. He said the public interest exception is narrow. It's not just about doctor preference or convenience. It's only justified, like in the earlier Edwards case, where there's objective evidence of a need to protect patient lives because the infringing product is the only option. Mere preference isn't enough. eValve v. Edwards Life Sciences really drew that line.
That's a really important distinction. It has to be about actual patient safety, not just liking one product better. It poses that tough question for you listening. Where exactly should that line be drawn between IP rights driving innovation and the immediate needs of public health?
It's one of the hardest balances the courts have to strike.
Okay, so final injunctions stop the infringement, possibly even beyond the IP expiry with springboard relief, but subject to that narrow public interest exception. What about getting money back? Financial compensation.
Right. Monetary remedies. Once infringement is proven, the claimant usually wants financial compensation. And they have a fundamental choice between two main routes: damages, which is a common law remedy, or an account of profits, which is an equitable remedy.
Damages or account of profits. You have to choose one. Repeat. Elect between damages and account of profits.
Yes, that's absolutely key. They're mutually exclusive. You cannot have both for the same infringement. You choose which one you want after you've won on liability.
Okay, let's look at damages first. What are they trying to achieve?
Damages in IP are generally tortious. The aim is to put the claimant back in the financial position they would have been in if the infringement hadn't happened. Repeat. Restore the claimant to the position they would have been in had the infringement not occurred. Compensate for their loss.
So it's focused on the claimant's loss. How is that loss measured?
It depends on how the claimant uses their IP. If they make and sell the product themselves, and the defendant was a competitor pinching sales, the usual measure is the claimant's lost profits on those sales.
Lost profits. Makes sense.
But if the claimant mainly licenses their IP, or if proving lost sales is tricky, the measure is often a reasonable license fee or royalty. Repeat, lost profits or reasonable license fee. What would the defendant have paid for a legitimate license? The big case setting out these principles, especially for patents, is General Tire v. Firestone from 1976, Lord Wilberforce's judgment.
General Tire v. Firestone. Repeat. General Tire, key case for damages calculation. What about that parasitic damages idea, claiming for non-infringing stuff sold alongside the infringing item?
Yes. Can you claim for lost sales of, say, spare parts or consumables that weren't themselves patented, but were sold with a patented machine? The law has shifted a bit here. The older view may be hinted at in Polaroid v. Eastman Kodak.
Polaroid v. Eastman Kodak. That case again.
Yes. The older view was stricter. Damages only for the IP right itself. But the more modern approach, championed by Justice Jacob in Gerber v. Lectra in 1997,
Gerber Garment Technology, Inc. v. Lectra Systems, Ltd. Repeat. Gerber v. Lectra.
is more liberal. It says, yes, you can recover losses on those ancillary non-infringing items if that loss was a direct result of the infringement. If selling the main infringing product inevitably meant you also lost sales of the extras that go with it. Repeat. Gerber allows recovery for ancillary items if loss is direct result.
That seems more commercially realistic. Okay, so standard damages cover the claimant's loss. What about additional damages?
Additional damages. Repeat. Additional damages. These are special, and they're only available for infringement of copyright and unregistered design right.
Only copyright and UDR. Repeat. Only copyright and unregistered design right. Why just those?
It's just how the CDPA was written. Sections 97(2) for copyright, 229(3) for UDR. Their purpose is to go beyond simple compensation and reflect the flagrancy of the infringement. Repeat. Flagrancy.
Flagrancy. Like how blatant or outrageous it was.
Exactly. How cheeky, deliberate, maybe scandalous the copying was. The Nottinghamshire Healthcare NHS Trust v. News Group newspapers case discussed this under Section 97(2).
Nottinghamshire Healthcare NHS Trust v. News Group newspapers.
Yeah. There's been some debate if they're unique or like aggravated damages. Good example of flagrancy is Phonographic Performance Ltd. v. Reader from 2005.
Phonographic Performance Ltd. v. Reader. What happened there?
It was a DJ who kept playing music publicly without a PPL license, even after being warned repeatedly. The court said that was deliberate and flagrant and awarded additional damages. Repeat. Phonographic Performance v. Reader facts repeated, deliberate disregard of warnings. But there's an update here. Remember the enforcement regulations. They might be changing things. The case Henderson v. All Around the World Recordings suggested the factors in the regulations might now be used instead of or alongside just flagrancy. Repeat. Enforcement regulations impact. Henderson case.
So the basis for additional damages might be broader now due to retained EU law. Interesting.
Yeah, it looks that way. Okay, so that's damages. What's the alternative? Account of profits.
Account of profits.
This is an equitable remedy. Repeat. Equitable remedy comes from fairness. And its goal is totally different from damages. It's not about the claimant's loss. It's about the defendant's gain.
Taking away their profits from the wrongdoing.
Precisely. The objective is to transfer the defendant's profits that they made specifically from the infringement over to the claimant. Repeat the objective. Transfer defendant's profits derived from infringement.
Why choose that? It sounds like it could be complicated to calculate their profits.
It often is. It needs detailed accounting. But you might choose it if the infringer made way more profit selling the infringing goods than you actually lost in sales, or more than a reasonable royalty would have been. The Patent v. York Close case is cited as an example where the account was much larger than damages would have been. Repeat. Patent v. York Close account chosen for potentially larger recovery.
So if the infringer struck gold with your IP, you might want their gold, not just compensation for your loss.
That's the logic. It's also used in other areas like breach of confidence. Remember the AGV Blake spy case.
Are there limits? Can you only get profits they actually made?
Yes. Only profits actually made from the infringement. Generally, you can't get an account from someone who just helped but didn't profit directly, though the Lifestyle Equities v. Ahmed case recently looked at profits via employment contracts linked to infringement. Also, importantly, getting an account doesn't mean you now own the actual money the defendant made. That was clarified in 20th Century Fox v. Harris. Repeat these nuances.
Yeah.
Actual profits, limited for accessories, unless employment link, Lifestyle Equities, no ownership of the money, 20th Century Fox.
Okay, it's a personal claim against the infringer for the amount they profited. Now, what about innocent infringement? How does that affect these money claims?
Right, this is tricky and differs between rights and remedies. Innocent here usually means that they didn't know and had no reason to know that the IP right existed.
Okay, how does it affect damages?
For most statutory rights, copyright, design right, registered and unregistered, patents, innocence is a defense to a claim for damages. It's in the Acts. CDPA SS.972331, RDA S24B, PA 6221. Repeat. Innocence is a defense to damages for most statute rights.
So if you innocently infringe a patent, you might avoid paying damages.
Potentially, yes.
Yeah.
BUT, massive exception. Trademarks. There is no defense of innocence to damages for trademark infringement.
None at all for trademarks. Repeat. No innocence defense for trademark damages. Why are they different?
It's historical. The Gillette v. Eden West case explains it. Repeat. Gillette UK Ltd v. Eden West Ltd. Trademark law grew out of preventing misrepresentation. If the defendant's mark confused people, causing loss, it didn't matter if they were innocent the damage was done. Focus was on consumer confusion.
Wow, that history still matters. Okay, so innocence blocks damages for most rights, but not trademarks. What about an account of profits? Does innocence block that?
This is where you really need to pay attention. For patents, registered designs, and trademarks, innocence might affect whether the court grants an account, similar to damages. By UT, for copyright and unregistered design right, innocence does not affect the award of an account of profits.
Hold on, repeat that. For copyright and UDR, even if you're totally innocent, you might still have to hand over all your profits.
Yes, that's what CDPA sections 97.1 and 233.1 say. Repeat the distinction carefully. Innocence may account for patents, RDs, TMs, but does not account for copyright in UDR.
That's a huge difference. An innocent copyright infringer could still lose all their profits. Really highlights the need to know the specific rules for each right.
Absolutely critical. So let's recap the election. Damages or account of profits?
You must choose one. Can't have both. Repeat, cannot have both, must elect. When do you choose?
After the court decides on liability. You might even wait until the amounts for both have been calculated so you can pick the bigger number. Island Records v. Tring confirms election is post-judgment.
Island Records v. Tring. Elect after judgment.
And remember, you also can't have both additional damages for copyright UDR and an account of profits. That was Redrow Homes v. Bet Brothers. Repeat, no additional damages, A&D account. Redrow Homes Ltd v. Bet Brothers PLA. However, following the enforcement regs, in cases like Absolute Lofts v. Home Improvements, you can elect between additional damages or an account, whichever is higher. Repeat, elect additional damages or account, whichever greater. Absolute Lofts v. Home Improvements.
Okay, so you pick the best single monetary route after liability is decided. Got it. Are there any other remedies after trial?
Yes. Ancillary stuff, often used against counterfeiters.
Yeah.
Things like ordering the erasure of the infringing trademark from goods, TMA S15. And very commonly, orders for delivery up and destruction of the infringing items.
Delivery up and destruction. Repeat. Delivery up and destruction. Sounds final.
It is. Get the fakes off the market for good. The power is in the CDPA, SS99, 114 for copyright, SS230, 231 for UDR, and the TMA, SS1619. Repeat the statutes.
Does this only hit the manufacturer?
No, and this is important. These orders can be made against anyone possessing the infringing goods in business, even an innocent retailer who didn't know they were fake. The Legines v. It's At case confirms this. Repeat. Legines Ltd v. It's At UK Ltd applies to innocent retailers.
Wow. So a shop could be forced to hand over stock they bought innocently. Tough, but I guess it gets the goods out of circulation.
That's the policy aim. Finally, for copyright only, there's a quirky self-help remedy.
Self-help. Repeat. Self-help. Taking the law into your own hands.
Sort of, in a very limited way. CDPA Section 100 lets copyright owners physically seize infringing copies being sold in public, like off a market stall. But the rules are strict, it's risky, and really only applies to things like street traders, not proper shops. Repeat, self-help limited, mainly street traders.
Okay, a niche power. So that covers the civil court remedies, but does the state get involved too? Public bodies?
Yes, definitely. Especially with things like counterfeiting, which is a massive global problem.
How big?
The material mentions estimates like 10–15% of world trade lost to counterfeiting. Billions. Technology makes copying easy, creators lose out, governments lose tax. So the state steps in to help protect these private rights because it's a major economic issue. Repeat. Scale, 10–15% world trade loss. Rationale is economic impact.
So the state helps fight the big infringers. How?
One way is criminal liability.
Criminal liability. Repeat. Criminal liability.
Yeah.
So infringement can be a crime.
Yes, for certain rights, if it's done by way of trade. Repeat. By way of trade. Basically commercially.
Which rights?
Copyright, CDPA S107, trademarks, TMA SS.9293 covers making or dealing in fakes, and registered designs, RDA S.35ZA. This was added by the IPA 2014 for intentional copying of a registered design. Repeat these rights. Copyright, trademarks, registered designs, intentional copying.
What's not generally criminal infringement?
Patents, unregistered design rights, stealing trade secrets. They generally don't have specific criminal offenses attached in the same way. Repeat these exceptions.
Is it only aimed at organized crime?
That's a big focus. But it could potentially hit competitors too, as the Thames and Hudson v. DCS case showed. Repeat. Thames and Hudson v. Design and Copyright Artists Society. Penalties have got tougher over the years too.
Okay, criminal charges for some rights. What else does the state do? Border.
Exactly. HM Revenue and Customs, HMRC. IP owners can tell HMRC if they think fakes are being imported.
And HMRC can stop them.
Yes, they have powers to seize infringing goods at the border. Under CDPA Sections 111, 112 for copyright, and TMA Sections 8991 for trademarks. Repeat, HMRC Roll CDPA SS11014 FOLV, TMA SS.8991.
So state help via criminal law and customs checks.
Right, shows it's seen as a public issue, not just a private fight.
Okay, we've seen the IP owner has lots of powerful tools, but we started by talking about balance. Are there ways the law restricts the IP owner, especially how they threaten to use these tools?
Yes, absolutely. This brings us to Section 4.5, Public Policy Restrictions. Repeat, Public Policy Restrictions.
Why are these needed?
Well, remember, IP rights are monopolies. Litigation is expensive. There's a real danger that big companies could just threaten smaller ones with lawsuits, even if the claim is weak. The small company might just give in because they can't afford to fight. Repeat, Balancing Act, potential for abuse by threats.
That sounds like bullying with legal threats.
It can be. To stop this, UK law has something called a threats action.
A threats action.
It's
Repeat.
correct.
Threats action. Suing someone for threatening to sue you.
If the threat was unjustified, yes. The whole point is to stop IP owners making groundless threats, especially against downstream businesses, just to scare people. Repeat. Purpose is to curb unjustified threats.
Which IP rights does this apply to?
Patents, PAS 70, trademarks, TMAS 21, unregistered design rights, CDPAS 253, and registered designs, RDAS 26. Repeat these rights with threats action.
And what's not covered?
Crucially, it does not apply to threats about copyright infringement, passing off, or breach of confidence. Repeat, and no threats action for copyright, passing off, breach of confidence.
So you can threaten copyright action without risking being sued back for making the threat.
That's the position, yes. The way it works is a role reversal. The person who got the threat, or anyone aggrieved by it, becomes the claimant. They sue the IP owner who made the threat, who becomes the defendant. Repeat role reversal.
The tables are turned. What's the big risk for the IP owner here?
This is critical. In the threats action, the claimant can often challenge the validity of the IP right itself. So the IP owner makes a threat based on their patent, gets sued for the threat, and then the court decides the patent was invalid all along. The IP owner gets nothing and pays the costs. Repeat. Critical risk IP validity challenged in threats action.
Wow. Making a threat potentially puts your own IP right on the line. That's a huge deterrent.
It really is. To defend the threats action, the IP owner has to prove both that infringement happened and that their right was valid. Fail in either, and they lose the threats case. Repeat. IP owners' burden prove infringement A&D validity.
Are any threats allowed? Permitted threats?
Yes, the law allows you to threaten action over acts of manufacture or importation. Repeat. Manufacture and importation. These are seen as the primary infringing acts, the source.
Why allow threats against manufacturers importers but not others?
The idea is to protect people further down the chain, retailers, users. Repeat. Protects those further down supply chain. Focus enforcement upstream. Don't bully the shops.
Okay. And just telling someone your patent exists isn't a threat?
Correct. Simply notifying them of the right's existence is generally fine. Repeat. Notifying of right's existence is not a threat.
How does a court decide if it is a threat?
They look at it from the viewpoint of a reasonable recipient. Would they understand it as a threat of legal action? Doesn't need aggressive language. The L'Oreal v. Johnson & Johnson case looked at this. Repeat. L'Oreal reasonable recipient test.
L'Oreal? What if the threat comes from abroad?
If it's received and has effect in the UK, it's actionable here. Prince Philippa v. Prince Sports Group confirmed that. Repeat. Prince Philippa oversees threat actionable in UK.
Prince Pillas. And that distinction about threatening manufacture versus sale.
Yes. The Cavity Trays case highlighted this. Repeat. Cavity Trays Ltd v. RMC Panel Products. Threatening over manufacturing import is usually safe because of the exception. Threatening over sale or use might not be protected, so it could be an actionable threat if unjustified.
So IP owners need to be incredibly careful what acts they threaten over.
Absolutely. And the law was updated
Well,
recently.
yes. The Intellectual Property Unjustified Threats Act, 2017. Repeat. Intellectual Property Unjustified Threats Act, 2017. What did it do?
It aimed to make the rules more consistent across patents, trademarks, and designs. It introduced a common definition of threat, clarified permitted communications, and protected professional advisors, like solicitors, acting on instructions. Repeat. 2017 Act impacts alignment, definition, permitted communications, advisor protection.
So trying to make it clearer what you can and can't say without risking a threats action.
That was the goal. Finally, the material just mentions competition law as another constraint.
Competition law, how does that work?
Briefly, because IP is a monopoly, using it in certain ways could be seen as anti-competitive. In rare cases, it could even lead to compulsory licenses being ordered under PAS Port 51 or CDPASS 144239. It's complex, but just be aware competition law can limit IP enforcement.
Another check on the IP owner's power.
Exactly.
These threats, actions, and competition law really bring home that balancing theme. It's the system trying to stop IP rights being used unfairly. For you listening, do you think the threats rules get the balance right? Protecting small businesses versus letting IP owners enforce their rights.
It's a constant policy debate, that tension between private rights and public competition.
We have certainly covered a huge amount today.
We really have.
Let's try and summarize the key points from this deep dive on IP remedies. We've seen IP owners have a big toolkit.
Both before trial, interim injunctions, search orders, freezing orders, Norwich Pharmacal, blocking injunctions.
And after trial, final injunctions, and that choice between damages or an account of profits.
Plus other things like delivery up and destruction, state help through criminal law and customs.
But T, all balanced by legal principles like court discretion, strict tests, human rights, and specific rules like the threats action and competition law.
It always comes back to that core balance. Rewarding creativity versus keeping competition fair and serving the public interest.
And understanding it often means knowing the key cases. Let's just list those crucial ones again. American Cyanamid, Anton Pillar, Mareva, Norwich Pharmacal, Cartier, General Tire, Gillette, Redrow, Absolute Lofts, Phonographic Performance, Dyson, Edwards Life Sciences, Valve, Cavity Trays, Prince Penkly, L'Oreal.
Knowing what those cases stand for is vital. Repeat those names. American Cyanamid, Anton Pillar, Mareva, Norwich Pharmacal, Cartier, General Tire, Gillette, Redrow, Absolute Lofts, Phonographic Performance, Dyson, Edwards Life Sciences, Evalve, Cavity Trays, Prince Penkly, L'Oreal. They're your signposts.
They really help make sense of it all. So, our final thought for you, the listener. Given how powerful these remedies are and how they could potentially be misused, how well do you think the current UK legal framework, with all its checks and balances like the threats action, actually manages to balance the rights of big IP owners with the needs of smaller businesses and the public?
It's a question the law is always grappling with.
Thank you so much for joining us for this deep dive into IP remedies. We hope it's been helpful.
And thanks again to the University of London for making the source material available for educational purposes.
This deep dive was brought to you by Sinorbit Academy, Sri Lanka.
And finally, to everyone studying for exams, really, the best of luck. Go over these ideas, the cases, the principles. You can do it. Good luck.